revival of expired corporations. But before that, let's go first with corporate term. A corporation under revised corporation code, the RCC, a corporation shall have perpetual existence. Perpetual existence, it means to say limitless. A corporation is not anymore for 50 years. It is already limitless, perpetual existence already. Unless its articles of incorporation provides otherwise. It is only the articles of incorporation who will that will which will limit the existence of a corporation, the existence of the life of a corporation. So when it comes to certificates of incorporation, those issued prior to February 23, 2019, again prior to February 23, 2019, certificates of incorporation issued from February 23, 2019, except those dissolved corporations, shall have already the perpetual term. So the revised corporation code has the retroactive effect when it comes to the existence of a corporation. That is why prior to 2019, those certificate of incorporation issued prior to that date shall have the perpetual existence except those dissolved corporation. Unless it notifies the Securities Exchange Commission that it elects or chose to retain the specific corporate term. While those certificate of incorporation issued on or after February 23, 2019 shall have an automatic perpetual existence unless the articles of incorporation says so. So again, this revised corporation code shall have the retroactive effect when it comes to corporate existence. It has the corporation shall have already the perpetual existence, even those certificate of incorporation issued prior to February 23, 2019, except the corporation elects or chose to elects or choose to have or to retain its corporate term. A corporate term for a specific period may be extended or shortened by amending the articles of incorporation. Again, it is only the articles of incorporation that will limit the term or life of a corporation. No extension, take note that no extension of the corporate term may be made earlier than 3 years prior to the original or subsequent expiry date. How is that? No extension of the corporate term may be made earlier than 3 years prior to the original or subsequent expiry date. So it means to say no more extension shall be made earlier than 3 years. So it means to say 3 years before the expiration of the corporate term, there can be no extension. Again, this is the date of expiration. So prior to the expiration, 3 years prior to the expiration of the corporate term, there can be no extension of its term prior to the original or subsequent expiry date. Prior to the revised corporation code, the period was 5 years. So the old corporation code, 5 years prior to the expiration date of the corporate life, cannot make any extension. This time, in the revised corporation code, from 5 years, it becomes 3 years already. Only 3 years. 3 years from the date of original, from the date of original or subsequent expiry date. This is the expiry date. 3 years prior to the expiry date, no extension shall be made when it comes to the corporate term. If a corporation has a specific term in its articles of incorporation and it subsequently extends to it, there is no time limit to the period of extension. So again, if the corporation has a specific term in its articles of incorporation, it may choose or it subsequently elects to extend it. There is no limit as to the period of extension. So as a general rule, a corporate term may be as a general rule under revised corporation code, the existence of a corporation is already perpetual, limitless. However, it is only the articles of incorporation can lengthen or shorten the corporate term, provided 3 years prior to the date of expiration, no extension can be made. But years before, or if we can say 5 years prior to the extension, prior to 5 years prior to the expiration date of the corporation, there can be an extension. The extension is already limitless. No more period is prescribed. It's already a perpetual. Provided further that such extension of the corporate term shall take effect only on the day of the following original or subsequent expiry date. So it means to say 5 years, 5 years prior to the expiration date, the corporation chooses to extend its life, to extend the corporate existence, and the extension shall only take effect after the expiration period, diba? 5 years prior to the 5 years prior to the expiration date, there is already an extension. That the extension period shall only take effect after the expiration period or expiration date. So when it comes to revival of expired corporations, this is under section 11. A corporation whose term has expired, diba? A corporation whose term has expired may apply for a revival of its corporate existence. Again, a corporate term whose term has expired may apply for revival of its corporate existence, together with all the rights and privileges under its certificate of incorporation, and subject to all of the duties, debts, and liabilities existing prior to its revival. So again, a corporate term for a corporation whose term has expired may apply for revival, together with all the rights and duties or privileges under the certificate of incorporation, and subject to all of its duties, debts, and liabilities existing prior to its revival. The general rule is that the revived corporate term shall be perpetual. Yes, if there is revival of the corporate existence, it is already perpetual, unless its application for revival provides otherwise. So when there is the corporation may revive together with its article of incorporation. If the articles of incorporation states no term, so it means to say it is presumed that it is perpetual. But if the articles of incorporation states a period, then it shall follow. It shall be followed rather. Exemption. Revival of banks, banking, quasi-banking, and quasi-banking institutions, pre-need insurance, and trust companies, non-stock savings and loan associations, pawn shops, corporations engaged in money service business, and other financial intermediaries. Again, revival of banks, banking and quasi-banking institutions, pre-need insurance, trust companies, non-stock savings and loan associations, pawn shops, corporations engaged in money service business, and other financial intermediaries requires a favorable recommendation of the appropriate government agency. So again, as a general rule, the revival of the corporation shall be perpetual unless the articles of incorporation limits it. When it comes to banks, banking or quasi-banking institutions, pre-need insurance, pawn shops, savings and loan associations, and other financial intermediaries, they need or they are required to get a favorable recommendations from the appropriate government agency. Example, for pre-need insurance. So therefore, they will be getting a favorable recommendations coming from the insurance commission. When it comes to banking or banks, they need to get a favorable recommendations coming from the Bangko Sentral ng Pilipinas. When it comes to other institutions, financial institutions, wherein seeking for money investment, they need to get a favorable recommendations coming from Securities and Exchange Commission. Now, revival of expired corporations. Question is, what is the required number of votes for the revival of the expired corporation? The required number of votes for the revival of an expiration is at least a majority vote of the board of directors or board of trustees, and it must be concurred with the both at least majority of the outstanding capital stock. For non-stock, at least a vote of at least majority of the members. Again, if there is a revival of the expired corporation, it requires a majority first. It requires a majority vote of all the board of directors for stock corporation, and at least majority votes of the outstanding capital stock. For non-stock corporation, it requires at least a majority vote of all the members, board of trustees rather. It requires at least majority votes of the board of trustees, and concurring with at least majority votes of all the members of the non-stock corporation. So let's go with the minimum capital stock. Under this revised corporation code, the general rule is that no minimum stock. Stock corporations shall not be required to have a minimum capital stock except as otherwise provided by law, by special law. That's the general rule. Corporations are not required to have a minimum capital stock except otherwise provided by special law. Therefore, no more minimum subscribed and paid in capital. But still, there is a minimum paid up capital. Example, for cargo consolidator, it needs 400,000 pesos. Financing company branch, 1 million pesos. Insurance broker, 20 million pesos. Non-life insurance company requires 1 million pesos. The same with life insurance company. It means to say they need to have a minimum paid up capital in order to support their business. More of this. Pawn shop needs 100,000 pesos. Pre-need plan issuer 100 million pesos. Recruitment for local employment, if a corporation, 500,000. For partnership, 200,000. Security agency, 500,000. For school, for stock corporations, if it is a school stock corporation, elementary education, 1 million. elementary and secondary education, 2.5 million. And elementary, secondary, tertiary, 5 million pesos. So far, the school needs the same also with mining. Authorized capital stock. Authorized capital stock requires 100 million, while mining paid up capital stock, that is only 6,250,000 pesos. So the general rule is that there is no minimum capital stock paid in or subscription, but unless provides by the special law. So now let's go with the contents of the Articles of Incorporation. Under Section 13, the very first content that we must see in the Articles of Incorporation is the name of the corporation, the specific purpose or purposes for which the corporation is being formed, the specific purpose, name of the corporation, the specific purpose or purposes for which the corporation is being formed. Where a corporation has more than one stated purpose of the Articles of Incorporation shall indicate the primary purpose and the secondary purpose or purposes, provided that a non-stock corporation may not include a purpose which would change or contradict its nature as such. So, purpose. Next, the place where the principal office of the corporation is to be located, which must be within the Philippines, diba? The place of the principal office, which must be within the Philippines, and the term for which the corporation is to exist. If the corporation has not elected perpetual existence, if there is no term, then therefore it is presumed perpetual. Next, the names, nationalities, and residences of the incorporators. As we all know, incorporators, these are individuals who are signatories, originally signatories in the Articles of Incorporation. They are the founders. They can be considered as the founders of the corporations. These are incorporators. While those who are buying shares, buying stocks, they are considered as stockholders. Next, the number of directors shall not be more than 15 for stock corporation, while the number of directors shall not be more than 15. There can be one that is already OPC, the one person corporation, for stock corporation, but for non-stock corporation, the number of trustees may be more than 15, but not less than 5. That is for the number of trustees in a non-stock corporation. Minimum of 5 may exceed 15. The names, nationalities, and residence addresses of persons who shall act as directors or trustees until the first regular directors or trustees are duly elected and qualified in accordance with this code. Next, it be a stock corporation. For a stock corporation, the amount of its authorized capital stock, yes, there must be a stipulation of the authorized capital stock, the number of shares into which it is divided, the par value of which, names, nationalities, and residence or addresses of the original subscribers, amount subscribed and paid by each on the subscription, and a statement that some or all of the shares are without par value if applicable. If it be a non-stock corporation, the amount of its capital, the names, nationalities, and resident addresses of the contributors, and amount contributed by each. So the difference between the stipulation in stock corporation and non-stock corporation, in which in stock corporation, there must be stipulation of the amount of the subscription, authorized capital stock, while the non-stock only the amount of its capital and the amount of the amount contributed by each. In a corporation, there must be a stipulation of number of shares into which it is divided and the par value of each. Next, the last is that such other matters consistent with the law in which the incorporators may deem necessary and convenient. And also, an arbitration agreement may be provided in the Articles of Incorporation pursuant to Section 181 of the Revised Penal Code, a Revised Corporation Code. So, it means to say all other stipulations or other agreements between the incorporators, contributors, and shareholders will be placed here, provided not contrary to laws, in an arbitration agreement in case of dispute between these incorporators. So these are the contents of the Articles of Incorporation.